Good afternoon, welcome to our At Échelle event dedicated to what's probably one of the most topical and exciting, but also one of the most complex issues which competition enforcers have to face nowadays, which is how to incorporate sustainability objectives into our enforcement actions. And I am glad to be with so many of you here at the Rue de l'Échelle and also online. I have the pleasure to welcome a very special guest today, coming specially from The Hague to talk to us, Martijn Snoep, who's the head of the Dutch Competition Authority, the ACM. And I'm also here with Elise Provost, who's the advisor to the Rapporteur général of the Autorité de la Concurrence, coordinating sustainability issues inside the Autorité and chairing the sustainability network. And I'm sure we'll have an opportunity to hear more about the sustainability network. First of all, let me thank you very much, Martijn, for being with us today. Before we start, let me briefly introduce you. You've been the chairman of the Netherlands Authority for Consumers and Markets, the ACM, since 2018. Prior to this role, you were a managing partner in a leading international law firm in the Netherlands, De Brouw Blackstone Westbroek, working extensively on competition law issues and operating from Amsterdam and from Brussels, and maybe from Den Haag as well. I have to say that dealing with sustainability is a journey on which all competition agencies, authorities are embarked, particularly in Europe, where we've taken a number of steps, including the new Commission guidelines on sustainability agreements as part of the guidelines coming with the so-called HBER, the horizontal block exemption regulation. And we're going to talk about it, of course. But on this journey, some of us have been faster and have been blazing the trail, including the ACM, which is why we particularly look forward to hearing from Martijn about the motivation, rationale, but also the objectives and the method that the ACM has been following when dealing with sustainability. We've also been embarked on this path here at the Autorité de la Concurrence, and I'm sure we'll also hear from it, particularly from Elise, in the course of the discussion, in two ways, in a let's call it a positive way and a negative way, or maybe we could call that the carrot and the stick. So the positive approach to sustainability, which we're going to discuss at length in this conversation, also following from the Dutch example, is about carving space for companies to be able to cooperate on sustainability projects within, of course, the framework of competition law, but there is a general agreement that we should be able to identify such space under specific conditions, and we're also going to discuss them. And the more negative or repressive approach is also to be able to sanction behaviors by companies which either individually or collectively stifle progress towards sustainability. And we had an example here at the Autorité de la Concurrence, which is what we casually call le cartel du lino, which is a decision by the Autorité de la Concurrence back in 2017 to sanction companies which had colluded on floor coverage, particularly floor coverage for hospitals and long-term care institutions and the like. And not going into too many details, among other things, among other objections, One objection was that they had agreed and colluded to agree not to communicate on the environmental performance of these floor coverages, and that was one of the reasons for their being condemned. So we have both aspects which we are very much investigating, and we are very eager to learn from you, Martijn. So let me give you the floor, and thank you again for being with us today.
Well, thank you very much, and it's a pleasure to be here and to be able to discuss with you a topic that is very close to my heart. And that the good thing is that you will find me hopefully talking passionately about it. The bad thing is that I have difficulty to shut up. So
that's exactly my job.
Yeah, okay, very good. But I thought, based on what you were saying, is that what is maybe interesting to tell a little bit about how did we as ACM maybe become a front runner in this area. And it started actually with two decisions, a little over 10 years ago, that for those who follow the debate will sound familiar. There was an agreement among electricity generators that agreed to close their coal-fired plants. And second is a famous case, even I think more famous, the chicken of tomorrow case. Fortunately, I hear a snicker in the room, so people recognize this, which I think, as a result of its name, rings a bell among many competition lawyers around the world. What is interesting about those two cases is that in both cases we issued a negative decision, in the sense that we decided that both agreements were illegal and in violation of the competition laws. This was all before I took office, and I did what I think you probably did as well when you became the chair of the authority, is you do your kind of 100-day tour around the country, talking to business leaders, government officials, and so on. And if there was one consistent message that they gave me, is that we don't understand a thing why you prohibited these two agreements. And whether that is right or wrong, the fact that they all said that resonated with me and made me think, well, maybe we should clarify our policy, explain better why we prohibit certain things, but why we also allow certain other agreements that promote the sustainability. Because basically their argument was, yes, we understand cartels are bad, but this is obviously good for society, so why prohibit it? That was their gut feeling. And I also felt that if we wouldn't be able to answer this properly, not only would it lead to no agreements between companies for good causes, but at the same time, it could also undermine the legitimacy of our kind of true core competition policy. Because if people think that the cartel authority, the competition authority, is prohibiting things that are good for society, then maybe we should get rid of the competition authority altogether. So of course there are protections in place, and it is not as black and white, but I thought, well, this is a serious issue we need to address. So that's why we thought, probably we need to explain better what is allowed and what isn't allowed under competition law, and that's why we decided to draft guidelines. At the same time, we knew that there were some kind of pretty uncontroversial areas, but there are also some controversial areas, and that is in particular the extent of the fair share obligation under paragraph 1013. The Dutch competition law equivalent is identical, so we simply copied European competition law under our Dutch laws. So we have the same discussion in the Netherlands. And the reason why we drafted guidelines is that companies consistently confronted us, but also NGOs, members of parliament, and everyone else who was interested, by saying, we really want to cooperate and do good things for sustainability and for society, but the ACM doesn't let us do it, which is also not very good for your position as an authority in society. And that's why we came up with these guidelines, creating specific kind of safe harbors and to companies on what they can't and what they can do in cooperating for sustainability goals. We did two important other things which were new to us in these guidelines. Is first of all, we said, well, if you are still in doubt based on our guidelines, feel free to come to us. We're happy to talk to you, even at an early stage. If we don't need to have a final plan, but even if you have just an idea of something you want to do, feel free to contact us, and we'll be happy to give you guidance. But there was a big but after that. We said we need to do this in all transparency. So if you want guidance from us, kind of on paper, something that you can hold us to, then we need to make this public immediately. So, and we said that for two reasons. First of all, for legitimacy of the agency, but also to inspire other companies and to inspire other agencies around the world to see what kind of cooperation could fall outside the scope, outside the prohibition of the competition laws. And the second thing we said is that, well, even if you don't come to us, fine, you don't have to. But if you followed our guidelines in good faith, then we will not impose a fine. That is, if we still find a violation of competition law, and we will ask you to amend your agreement or totally abolish, rescind the agreement. We will not, you have to do that, but we will not impose a fine. And that lowered the threshold significantly for companies to come to us and for companies to enter into agreements. Now, our expectations were pretty high, and we had assembled a team of specialists and trained them and discussed with them how we would deal with these requests for guidance, and we're a bit afraid of the workload, but in a way, and that's either good or bad, we still don't know which one of the two it is, we weren't overwhelmed with requests for guidance. And that can mean a couple of things. It can mean, first of all, that we were just used as an excuse not to enter into an agreement. Could be. It could be that our guidelines were so clear that no further guidance was necessary. Could also be. Or it could be that our guidance wasn't clear enough and that there was still a lot of doubt, particularly because until this moment, it is not clear what the European Commission's point of view is. And most, I would say, meaningful agreements in the Netherlands have an effect on trade between member states, and that could also mean that the European Commission is involved. But nevertheless, we were approached about, in I think 2.5 years, we were approached about 20 times by different initiatives, which led to 5 kind of informal guidances that we published. Of course, we were approached at an earlier stage, and some of these agreements didn't go through, or it was just testing the waters. But ultimately, we were able to give 5 informal guidances, and they're kind of nicely spread out over the 4 categories of agreements that we considered in our guidelines. The first category is an agreement that is virtually no restriction of competition. An example is an agreement among soft drink bottlers that agreed to modify the plastic handles of their multi-packs, small reduction of plastic, but a significant improvement of the recyclability of the plastic wrappings. After an investigation, we found that soft drink bottlers do not compete on the handles on the multi-packs. It's not a parameter of competition. Price and brand are more important than the wrapping. Of course, you could wonder, why did they ask us for guidance? They found out themselves that it was not a parameter of competition. My answer to that is there were a couple of big international companies involved, active in the soft drinks industry, who regularly run into problems with competition authorities, so they didn't want to take any risk. The second category is, if there is the restriction of competition relates to what we called illicit or illegal competition. And an example of that case is where the garden centers in the Netherlands, they sell plants. Most of the plants are grown in greenhouses in the Netherlands. And the producers of these plants use illegal pesticides, and it's endemic. And for the environmental authorities, it's extremely difficult to detect the use of the illegal pesticides in time. And therefore, the garden centers decided to introduce a collective boycott scheme where growers who would use the illegal pesticides after one warning would be blacklisted for a year, and then with a certificate of good behavior, they could be reintroduced as a supplier to the big garden centers in the Netherlands, having more or less 80% market share in the Netherlands. So it was a significant a boycott with significant impact. But we argued that, and we made this explicit in our informal guidance, that the competition laws are not designed to protect illegal competition based on the use of illegal pesticides. It can't be true that our competition laws kind of protect this type of competition. We don't, and therefore it falls outside the cartel prohibition. And then the third category is if there is no significant effect on competition. It may well be that the parameter of competition is being affected, but the price or effect on quality is very limited. And a case, an example of that case is an agreement among regional grid operators that agreed on a certain harmonized way of procuring new investments into the expansion of the electricity grid. And electricity grid operators do not compete. They all have a regional monopoly, but they do compete in a yardstick competition benchmark. So the cost drivers of these regional grid operators are being compared in a benchmark study, and then their prices are being regulated on the basis of the benchmark model. So therefore, there's a sort of indirect competition, if you may. So if they all use the same procurement way of procurement, if they agree on a similar way of procurement for investments. But we said, yeah, but that is not a significant impact on competition, and therefore it falls outside paragraph 1 of our cartel prohibition. And then the final category is the hotly debated category of whether the benefits of the agreement outweigh the harms to consumers. And there's, of course, it's a question of whether the consumers are getting a fair share of the benefits. And this is now at the moment also the topic of discussion within the ECN and with the European Commission, and many of the international debates are now focusing on this type of agreement. And the agreement that we analyzed under this in this fourth category is an agreement between Shell and Total, which relates to a joint project for CO2 storage under the North Sea, where they jointly agreed during an initial phase to jointly market, sell and market CO2 storage capacity under the North Sea in this joint facility that they were operating. And we analyzed that joint marketing scheme under our equivalent of paragraph 3, where we have two types of analyses under paragraph 3. One is what I would call a quick look analysis, where it is clear that the benefits greatly outweigh the harms. We do not require a full econometric or economic analysis of the reduction of CO2 versus the price increase, and a full-blown analysis where everything is being calculated and up till the detailed numbers. We did something which I think is a bit of both, because also we wanted to show it as an example on how you can calculate benefits, CO2 benefits for society under paragraph 3, and how you can outweigh them against the harms for consumers. In this case, this was not a very, in a sense, not a very difficult case, because the benefits clearly outweighed the harms, but nevertheless, it shows a bit of a way on how we calculate these benefits, and it's something that we can discuss. For those of you who are interested in economic calculations of benefits, I can highly recommend a joint study we commissioned together with the Greek authorities to a group of economists, and that gives a number of examples on how to calculate sustainability benefits in a paragraph 3 analysis. So this shows a little bit of an overview of how we came to our guidelines, how it works in practice, and probably now it's a good time to stop.
Thank you very much, Martijn. There is a lot to process in what you said, because you've covered so much ground. I mean, both in theory and in practice. And I'm glad that you focused on practice, because that's what we want to know more about here at the Autorité de la Concurrence, and also that's probably what's of interest to the audience, the online audience, including companies, lawyers, and the like, because they want to know, how it works when it's in place. But let me turn to Elise and let you comment or ask questions to Martijn.
Thank you. I have a first question on informal guidance. So you just mentioned your informal guidance experience. As you know, in many agencies, several agencies across Europe, we have neither a legal basis to undertake informal guidance, nor a long-lasting experience on individual ex-ante guidance, at least on sustainability. So my first question would be, could you explain us, could you describe the mechanism you've implemented on informal guidance at the ACM?
Yes, it is really informal. So we do not have a legal basis to give informal guidance either. So it has the form of a letter that we send to the parties or their representatives, where we give our analysis of the case they're put forward to us. We do a proper investigation. Of course, it's not the same as a cartel investigation or a merger investigation, at least so far. It's also done openly, so if it's relevant and if there is any kind of opposition, we also talk to third parties with, of course, with the if the parties agree to that. So that is an important point. And basically, we can go as far as the parties let us go. But if the parties, for some reason, only feed us very limited information, we can be at a certain point in time where we say, well, we cannot give informal guidance. And the more you let us, you give us, the more information you give us, the better our guidance is going to be. So that's a bit of a dance. But I think in what we found is that actually in good cooperation with the companies and their representatives, we find the right balance in their giving sufficient information to us, allowing us to check that information with third parties, and at the same time give guidance based on the information they're providing to us, and which has some value to the companies. The most important value being that, legally speaking, if we write to companies that we will not impose a fine, we can't. So the courts will immediately say, well, yeah, if the facts are the same, you cannot impose a fine. So, and we are pretty straightforward with that. And in our experience, that gives the parties and the companies enough confidence to execute and implement their agreement.
Okay, thank you.
No, if I can ask two small follow-up questions, really on this process, do you also have instances of more informal discussions with firms? Like they're coming to you saying like, look, we would like to do this and that. And then the answer is already like, don't think about it. It's never going to work. And so don't bother sending us the details because we don't feel like it's going to work. Is that the kind of things that you could say?
Yes. Yeah. So it's sometimes we're being approached by companies and they say, okay, we want to do this fantastic new project, but we also want to agree that the prices will increase by 10% to cover for the costs. And then we say, well, no way. That is a red line. You know, we are happy to talk with you about kind of your cooperation agreement, but price agreements are out of the question. And so, and then sometimes, and that's why we have kind of more initiatives that approach us than guidances. And sometimes then the companies stop and say, okay, well then it's not in our interest. We don't want to pursue it, and that's fine. Of course, I think like many authorities in Europe, we were very reluctant to give informal guidance because it takes resources, and resources you cannot spend in running investigations against cartels or abuses of dominance. But we thought that sustainability and the move towards a more sustainable economy is such an important drive for society that needs to be underpinned by private action, that it's worth spending public resources on giving these types of guidance to make sure that the right types of agreement are being entered into it. Because ultimately we believe that competition law should not stand in the way of genuine sustainability agreements between competitors. And of course there's a lot of nuance there, and there's a couple of buts you need to enter into that. But fundamentally, we believe that competition law is here to serve the public interest, and the move towards a more sustainable economy is in the public interest, and therefore competition law should at least not stand in the way. Often in the discussions I'm having, sometimes with the Commission or sometimes in Europe or in other international groups, it's being suggested that we see competition law as a solution for environmental problems. That's not the case. I mean, so we are not saying that competition law can be used, it can play a role, but the most important thing is that we believe is competition law shouldn't stand in the way. This comes from the two cases I started with, the coal-fired plant and the chicken of tomorrow case. But ultimately, of course, other mechanisms and other policies should have a bigger impact on the environmental problems that we are facing. But the very least, what competition law should do is not stand in the way.
Thank you. As you just said, we have to build new relationship or different relationship with stakeholders if we really want to play our part in sustainability. But another question on informal guidance is also to find the right balance between legal certainty on one side and the need to remain efficient, as you said, as a competition agency. One way to do it, or to find the right balance, seems to accept that in many cases parties will not need a comfort letter or a stamped decision, but will accept only press releases or informal advice. Is it something that you've seen at the ACM?
Yes, I think so when we issue informal guidance, it is in the form of a letter, and then we publish the letter together with a press release. And I think ultimately the work is in the analysis and not necessarily in drafting the informal guidance. And so there is little efficiency to win if we would decide not to issue an informal guidance letter, but just a press release and do the analysis. So ultimately, we've never had the situation where we said, okay, we'd rather not issue the letter and just a press release. Sometimes our informal guidances can be pretty brief. You know, if there is no parameter of competition being affected, so there's no restriction of competition, then it's I can't recall how long the informal guidance was, but it can't be more than 1 or 2 or maybe 3 pages. So that's a very simple informal guidance. It's the more complicated paragraph 3 analysis that requires more paper, but it's not, by far, not all agreements relate to that 4th category that requires that important, more difficult and complicated analysis. And this is also the message I give to businesses. Try to find a way where you can stay in the first 3 categories. A lot of things are possible in the first 3 categories, and yes, sometimes it is necessary to get into a paragraph 3 analysis, but see whether it's really necessary to do so, because the indispensability test for many of these cases is a very difficult hurdle to take. So that's why we are not afraid for companies that come to us with sort of agreement on standards. Say, well, if you don't want a price agreement on top of the agreement on the standard, is not going to meet the indispensability test, and we can immediately block that out.
It seems to us that indeed the vast majority of cases will fall under 111 and will escape the prohibition given the legal and economic context and the way they are designed, actually, and they can be designed to be compliant with competition law and on standardization in particular. Nonetheless, some complex cases may arise as well with out-of-market efficiencies, in particular in terms of negative externalities reductions, such as CO2 emission reductions. And in such cases, you've decided to rely on 113. So my question, as the Commission did actually, and my question would be, why did you choose 113 and not, for example, the ancillary restraint tool?
So we thought long and hard about kind of the ancillary restraint angle and the 113 angle, and ultimately we said maybe we could argue some of the cases under an ancillary restraints doctrine, but probably paragraph 3 was specifically designed for these types of issues. If you go back to the treaty and the origins of European competition law and how the law was drafted, the treaty was drafted, and the ideas behind competition and anti-competitive agreements with positive effects in the public domain, I think paragraph 3 was specifically issued for these types of situations. So that's why we decided for the clarity and the consistency of competition law to explore this area further. The main controversy, and I think where we're now in the debate, is it is generally accepted that environmental benefits are benefits in terms of the first strand of paragraph 3. The key question is, what is a fair share for consumers? And there, the 2 arguments are, on the one side, a fair share is only achieved if the consumers are being fully compensated for the harms. And our interpretation of paragraph 3 is no. A fair share is if the consumers receive a benefit, but society at large benefits more than the harms to the consumers. And this comes from the idea of the negative externalities, because what is fair in our view should always be done in a context-specific situation. You cannot say, well, this is fair in all situations, but in the context of situations where there are negative externalities, like CO2 emissions, combined with the polluter pay principle, which makes it more kind of efficient, but also more fair, that ultimately these types of agreements are being exempted from the cartel prohibition if the society as a whole benefits more than the consumer's price increase.
Yeah, if I may interject at that point, I think first it's no secret that when the new horizontal guidelines were discussed in the ECN, there were different views about what the definition of the fair share, ranging from it has to be fully given back to consumers to some of it has to go to the consumer, and it seems to me, but correct me if I'm wrong, Martijn, that we are kind of moving beyond that discussion. That is the competition community in Europe is very much now focusing on practical cases, which is a discussion we're having today, in fact. And also, my take on that discussion is that it's probably more interesting in theory than in practice. That is, there are many cases where the consumer is on board anyway. So there are few cases where the consumer would be against the kind of environmental achievements, improvements that would be brought along by the agreements. I mean, I'm sure we can identify such cases, but I don't expect them to be that many. And in many cases, the consumer is anyway on board because consumers want their products to be sustainable, and they want their product to save carbon, and so interests are aligned in a way, and so the theoretical discussion on consumer welfare is probably not that interesting in practice for that kind of cases. But that's my personal take.
You want me to comment? Yeah, I'm not sure. I mean, first of all, I agree that the number of cases that deal with this specific problem is limited. But that could also be because what the authorities are expressing and giving guidance is restrictive. So there's a bit of a chicken and egg discussion. So this is one thing. And second, in our kind of market studies to consumer behavior, there we saw, not surprisingly, that there is a huge difference between the stated preference of consumers and the actual preference of consumers. So yes, consumers often say that they want to pay more for more sustainable products, but we also see in reality that as long as the unsustainable product is still available in the shelf, in real practice, they do not show that willingness to pay for the more sustainable product. So I think the more difficult cases will come when, for example, supermarkets would agree to totally abolish a certain unsustainable product from their shelf, which leads to a price increase for consumers. And then, of course, that is a question, I think, and that is a real question under paragraph 3, and depending on what your view is under paragraph 3, that could be exempted or not. So I expect that the further we go into into this sustainability route, these questions are likely to be popped up, and there are genuine views on either side. So I'm not saying that the others are completely wrong. We see there are also two questions to it. You can see it as a matter of law or as a matter of policy, and that also makes a difference. But ultimately, this is, in the system that we're living, this is for the Court of Justice to decide what the extension of the extent of paragraph 3 is.
No, I fully agree that there will be cases where different objectives are not aligned. Maybe one other answer, and here I'm thinking very much as an economist and not as a lawyer, is that these are cases where the externality is coming with, say, CO2 emissions are not being internalized by consumers. But the right tool, the right instrument to make consumers internalize an externality is not competition policy. It has to be something else, taxes or regulation. So that could be also the answer.
No, I fully agree. And I think so we all agree that these negative externalities, particularly CO2 emissions, are causing a market failure that, you know, is probably the biggest market failure in human history. But second, we not only have a market failure, but we also have a regulatory failure. Because normally a negative externality would be addressed by regulation. I fully agree with that. But here with this particular negative externality, we have a significant problem because those who benefit from not incorporating the negative externality in the prices, that is today's consumers, most of them will, we like it or not be alive when the harms kick in, when our countries become inhospitable, or when at least part of my country will be totally flooded, and therefore that makes it extremely difficult in the political process to find a proper majority for regulation that really addresses these negative externalities. And I think this makes this type of externality different. So we see a market failure, but we also see a regulatory failure. If you look at the big COP conference in Sharm el-Sheikh a couple of weeks ago, I mean, it was a regulatory failure right in your face. And then, of course, the question is whether, I think I fully agree, the economist, policymaker, even lawyers' answer to the question is, shouldn't it be regulation? Whether we should stop there, and there, I think we as a ACM think no. As a competition authority, we have an obligation also to step in and to apply the law. So we are not. So the only thing is what we say. Well, we have paragraph 3. This is designed for these types of situations, and let's apply it properly, and not kind of say, well, okay, we'll leave it to regulation, because the regulation is not coming.
As you mentioned, the polluter pay principle, do you consider it as the beginning of the answer to know whether we have to act or not? I mean, some proponents of a stricter approach of 113 claim that there's one risk with the broad interpretation, is that we will open the door for other considerations, such as labor protection, such as national preferences, for example. Do you see the polluter pay principle, as an answer to not open the door too much?
Yes. Let me answer in a couple of questions. I think the polluter pay principle is both from a economical, legal, but also kind of a moral point of view, is here a guiding principle in what we do. I think this is, basically the idea, do not to others what you don't want others to do to you. So it's a fundamental principle of how our societies are being built. So therefore, I think it's an extremely important principle that we should adhere to, apart from the legal obligations, why we should. Second, I see the kind of the policy danger, in the sense that if you open paragraph 3 to kind of a wider interpretation, yes, it is also possible that other types of agreement could fall within the scope of paragraph 3. My answer to that is, well, twofold. If that happens, why is that bad? If it's good for society, it's good for society. Whether it's labor or sustainability, but we have to be strict. So we, as competition authorities, like we are skeptical in merger control in the sense of efficiencies, and we also have to be skeptical in environmental benefits. We have to be vigilant as competition authorities. So it's not, we shouldn't believe in fairy tales that companies are putting in front of us. So I don't find the argument convincing is that we shouldn't do this in sustainability, because the effect may be that we also have to approve other positive agreements for society. So this is the second argument. And the third argument is, okay, so we weigh now the downside of having to exempt other agreements against the positive effects on sustainability. And I think the dangers of not addressing the negative externality of CO2 emission require some risk taking. And I would say, okay, if we, on the one hand, are able to contribute, competition law is not going to save the world, but contribute to saving the world, you know, we may take a little policy risk in other areas.
I think I probably agree 98% with what you said. The remaining 2% being about who's going to decide what's good for society, and that's very much my former European self speaking here. That competition policy is a European policy, and there is a single market, and the Commission also enforces 1013, and we need consistency here, but there could be a variety of preferences across member states on some issues, which we don't have on sustainability. So sustainability is one area where we have a clear policy of the Union, so it's a no-brainer from that perspective. But in some other areas, you could have diversity of preferences across member states, and then what do we do? Yeah. So that could be, you know, something that we have to be mindful of, which kind of leads me to a question, which is about who's deciding on what's good for society, or more practically, did you, as ACM, did you ever defer or at least consult other authorities when it comes to assessing the benefits of, say, you know, carbon capture or animal welfare and etc. How do you interact with other authorities in charge of these kind of issues?
Well, I think for us, right from the beginning, we said everything we do in this area, particularly because of the kind of the democratic legitimacy issue, which I see. So I agree with your 2%, because I think that is the most vulnerable part in the analysis. But one step back, the reason why I think we can, well, there are two reasons why I think competition authorities can nevertheless do this. First of all, because the democratic legitimacy is in paragraph 3. So our legislators gave us paragraph 3 to make this analysis, so then why not use it? And second, the legitimacy is in the fact that there is a regulatory failure. I mean, everyone agrees that the legislator is not doing the right job. So that's why I think that twofold legitimacy. Nevertheless, being an unelected official, I think transparency is extremely important in this area, and of course, you know, there should be a proper due process and a right to appeal, which we all have in place, also for these types of cases. And ultimately, it is up to the courts whether we apply paragraph 3 correctly or not. So I feel that, you know, maybe there may not be democratic control directly over our decisions. There is judicial control over our decisions, and that gives us the legitimacy. And thirdly, what we said, coming back to being transparent, I also believe that our decisions have to be very strongly based on economic evidence, you know, like in our merger decisions. The problem is these are all prospective analysis. So there is a margin of error like you have in merger control, but the least what you can do is provide proper and sound economic evidence. And so like we do in merger control, we try to predict the future, and that is very difficult, we all know that. But it is doable. And therefore, we invested a lot of time and effort in finding right ways in measuring these economic benefits. And it's actually kind of interesting because when we started on this journey, I would say, I immediately got our chief economist on board and asked the chief economist, you know, think with me how we're going to calculate the benefits. And the chief economist said, well, I don't know. He was had a long career also in private practice as an economic consultant in competition cases. But like me, he had no experience in calculating environmental benefits. So we went on a tour and talked to academics, and we didn't get a very satisfying answer, and we thought, well, it's probably extremely difficult. Then we came to the Environmental Planning Agency in the Netherlands. So we have a separate advisory body for environmental planning in the Netherlands. And we asked them the question, how do we calculate environmental benefits? And they looked at us, and they didn't understand the question. And so we asked it again, how do we calculate environmental benefits? And then they said, yeah, but that's obvious. We've been doing that for the last 25 years, and there are all kinds of models, and there's lots of literature, it's peer-reviewed academic literature and research. And it was just because me and my chief economist, we were both, living in our competition bubble, and in that competition bubble, there was little or if no experience in measuring environmental benefits. But in another bubble, there was plenty of experience with it. And they helped us along the way, and they showed us, what are good ways and less good ways, and it was this cooperation was extremely fruitful. And now in our chief economist team, we also have sufficient capacity to properly calculate the benefits, and that makes us, keeps us honest, and because the tendency is, of course, to believe in good stories, because we all want the planet to survive. So we have to tie ourselves to the mast, like Odysseus, and do not listen to the songs of the sirens, and be very critical and to find robust, strong evidence of benefits, and that's, I think, economic theory and econometric calculations help us with that.
We have a few minutes left, so let me suggest that we give a chance to the audience to ask questions if they want. If anyone wants to ask question, but just use a mic because we have followers online, and so they have to listen to be able to listen to the question. Either no, Fabienne.
Have you identified have you identified sectors which are or are not interested by your informal guidance?
I think there is interest across sectors, and so we have in retail, in electricity generation. No, it's really across all sectors that we get interest. I expect more to come from the agricultural industry, and the reason is that the Commission, in its regulation on the common agricultural market and the exemptions for market organizations, agricultural market organizations, was far more liberal than under paragraph 3. So I think and that is an area that is to be discovered by the agricultural sector. We issued specific guidelines for the agricultural sector because of the more lenient regime for the agriculture, and I expect more requests for guidance from that sector anytime soon.
Any other question? No? Yes.
Yes, hello. You mentioned the problem of stated preferences versus what consumer actually do, and it's going to be a problem from any kind of economic analysis. Do you think it's almost something you should take a stance on in your guidelines? Because eventually when you have a negative externality, what consumer do is not the right thing. Yeah, thank you.
Yeah, correct. So, so in some of our cases and in some of our research, we specifically address the problems between the actual preference and the stated preference. We also did experiments, so where we gave consumers a virtual wallet to buy products, virtual products, and even in the virtual world, their stated preference is different than their actual preference. I thought it was quite revealing. But it shows how difficult the problem is. And that's also, I think, that lays at the foundation of why our legislator has difficulty in drafting and accepting laws that are going to lead to price increases for consumers, because the negative externalities are being incorporated. And it's also the reason why probably also companies find it difficult to enter into an agreement that that will lead to the incorporation of negative externalities, because they're afraid of losing customers if not everyone joins. There is a specifically for this reason, there is a significant first mover disadvantage, that if one company goes along individually and incorporates negative externalities in its price, then the chances are significant that it will price itself out of the market. So that's why we see this as a fundamental problem, but it also ties into the democratic legitimacy problem that you addressed earlier. So I think it's hard. There is hope, though, in the sense that we see the stated preference increasing. So we see the number of consumers increasing that are saying that they're willing to pay a higher price. And if you look at other research, they say that an increasing stated preference is a good indicator for future behavior. So this is the hope I have for our future.
Yeah, I was going to say that's part of a kind of evolutionary process or dynamic process whereby consumers are learning about what's good and what's not good, including for them. And there are paternalistic answers, like just stop buying this and that, which are sometimes in regulation. But it's also about information. Yeah. So that kind of experience we are through, can also help inform a discussion on what information can help consumers figure out the consequences of what they're doing. So we have these, awful pictures of sick lungs on tobacco packets. We could have photographs and images of floods and fires on products which are carbon intensive, and I'm not joking. Maybe that will come.
But you still see a lot of people smoking, though, but I think you're right. This is a way forward, and it's also, we are also a consumer protection agency, and that's why we have a very strong program and also issued guidelines against companies using misleading sustainability claims. Because what we do want is that if companies claim that they have a green product, then it's also actually green. So we issued, we settled 2 cases in the garment industry, clothing industry, one against H&M and the other one against Decathlon, and for using misleading sustainability claims. And we also recently settled 2 cases against 2 energy suppliers that were claiming that their energy was more green than it actually was. Because we believe that at the same time we should actively enforce against greenwashing, and consumers must be able to trust the sustainability claims these companies are making. But it is also in order to avoid free rider problems, because if one company is claiming that its products are green and it's making the costs and the effort to indeed make it green, but the other company can do the same, can claim green without making the cost, then it will soon be over with investing in green. So that's why we both, from a point of view of consumer protection, but also in a way to avoid unfair competition or free rider problems, we actively enforce the consumer laws against sustainability claims, false sustainability claims.
And here I get there is an important parallel to be made between that discussion we're discussing today and the discussion on competition policy and privacy, where we also have an issue of stated preferences being different from actual preferences, the privacy paradox. So there is a sustainability paradox just as there is a privacy paradox. And we have intense discussions with data protection authorities on dark patterns. And you also have dark patterns in on green and sustainability. So it's the same discussion.
Yeah, for me, I agree. There are a lot of parallels, but I think there's also a big difference. Is that in privacy, it is your personal data that is being shared. So basically, you inflicting harm on yourself. And with sustainability, you inflict harm on others. And I think that difference is, for example, also why we make a difference in our approach between those agreements that aim to protect, for example, animal welfare. Because yes, animal welfare is in extremely important, and there could be some infliction of harm on other human beings. If I eat meat from maltreated animals, of course, I also inflict harm on someone who really cares for animals, but it's of a different nature, and that's why I think we have to make a distinction between if I consume products and the production leads to more CO2 emissions, I really inflict harm on someone else. So that's a different type of harm. So even in the harms, we have to make a distinction and cannot lump it all together. And this is also, I think, in a discussion on sustainability, we have to be both on the fair share analysis. We have to be very clear on and make a contextual analysis on when fairness requires full compensation and where fairness can require less than full compensation.
So I guess that's a very important work program, but you're starting from a very solid basis, and we're also following the same path. So there will be more to come. And again, thank you very much, Martijn, for joining us today.
Thank you. Thank you.